Yeah, my pleasure. Yeah.
We're going to move to our second panel now and thank our witnesses very much for joining us from Australia. I would just note for anybody who's following that we will be respecting the 2-minute silence at 11 o'clock to mark remembrance, and we will pause the committee at that point. Can I welcome Professor Natalie Klein from the University of New South Wales and Madeline Gleeson from the University of New South Wales. We are very pleased to have both of you here joining us for this morning and this evening for you. Really grateful, particularly given the time difference as well. Can I ask each of you just to begin with to tell us the work that you have done on the Australian policies around turnback and also the offshore processing of asylum seekers, and just very briefly your overall assessment of that approach, beginning with Professor Klein.
Thank you, Chair. My main area of research focus is really on law of the sea. So where my expertise lies is with migration by sea. So what I have been looking at is the legality of Australia's turn back the boats policies in relation to different international laws that apply to that practice, and also looked at it with some colleagues in a comparative perspective in relation to the Mediterranean experience as well. So in relation to that, my key interest has been in trying to see if Australia is conforming with all the applicable international laws that apply in this situation. That includes the UN Convention on the Law of the Sea, the Search and Rescue Convention, the Safety of Life at Sea Convention, the Migrant Smuggling Protocol, as well as the Refugee Convention and human rights treaties. And I note that the United Kingdom, I believe, is parties to all of those agreements. But unlike Australia, the UK is also a party to the European Convention on Human Rights. And if there was probably one key point in assessing Australia's practice, there are many different steps that countries can take in terms of policing and trying to take actions against migrant smugglers at sea. But the key issue that you have is when you are rescuing people at sea or detaining migrants at sea, that the moment that you're exercising control over those people, then human rights obligations attached to that. And that has probably been the most critical issue for Australia in terms of really serious questions about whether Australia is adhering to its human rights obligations. And I think those questions are even more important for the United Kingdom, given its membership of the Council of Europe.
Thank you. Madeline Gleeson.
Thank you. I am a Senior Research Associate at the Caldor Centre for International Refugee Law, where I direct our project on offshore processing. So while I am an international lawyer by practice and by training, my focus since 2012, really since we reintroduced this policy, has been on Australia's offshore processing policies, as well as the implicated aspects, the other aspects that come with that of Australian refugee policy. In terms of a key message, there are many very serious legal and humanitarian concerns with what is called the Australian model for offshore processing. And I'm very happy to take the committee to those, but the main point to make is that this does not work. It did not work in Australia. It was introduced with the goal of trying to deter people from seeking asylum in Australia by boat. But in fact, in the first 12 months of the policy, we saw more people arrive in Australia by boat than at any other time in history or since. In fact, in the first 3 months of that policy, we already had so many people arrive by boat as to outstrip the forecasted capacity of those detention centres. And so already it was abandoned and most of the people had to remain in Australia. Really, we only saw the number of people arriving by boat drop once Operation Sovereign Borders was implemented, which is the boat turn-back policy. That also has very serious legal and humanitarian concerns, which Natalie will speak to. But the main point on offshore processing is that did not deter people from arriving in Australia by boat to seek asylum.
And then, so just to clarify, so in terms of when the policy was introduced and how long the numbers stayed high for, because obviously your numbers have dropped very significantly now. What were the timings?
Thank you. So we had a first iteration of offshore processing that was introduced in 2001 for a few years then. That was wrapped up by 2007, but really most of the people had been resettled already within a few years. So when I'm talking about offshore processing now, it's in its second iteration, which began in 2012. It was introduced at that time in response to what had been increases since 2009. So since about 2009, 2010, the number of people arriving by boat had been increasing, and Australia was looking for a way to respond to that. Offshore processing was introduced in August 2012, and the financial year of 2012 to 2013 was when we had a massive increase in the numbers. I can pull that up here. I've got it here. Until then, the numbers had been 1,000, 6,000, 5,000. In the first year of offshore processing, it was 25,000. Then once Operation Sovereign Borders was introduced and boat turnbacks began, that dropped back down. Effectively, the numbers published are zero. That number is not accurate because we know that people have arrived by boat and been brought to Australia and then flown back to their country of origin. So the number is not zero, but it is significantly less than the 25,000 people we saw in the first year of offshore processing.
And your assessment that the offshore processing wasn't responsible, you're confident about that in terms of the timings of the introductions of other measures, that there wasn't just a sort of a lag in terms of people understanding what the impacts were of policies or things like that?
I think that the lag argument could certainly hold in those first few weeks and months. That was the government's argument at that time, that it's going to take some time for the communication of this policy to flow through, but not when you look at the fact that over a year it was still going on. And it was really upon the introduction of boat turnbacks that we saw that drop off. I guess other evidence that I might point to support this claim is that the Australian government itself has not sent someone offshore since 2014. This has not been a policy that even Australia has been pursuing for about 6 years now. Actually, what we've been doing is trying to extricate ourselves. But because there was no exit strategy, Australia really has been mired in this policy for about 7 years now, longer than it wanted to be. We have not been sending anyone new offshore. In fact, the vast majority of people who are technically subject to this policy are actually in Australia right now. They've been transferred back here because the conditions offshore were so inadequate that they've had to be returned here for health reasons and other reasons.
And at the point at which Australia stopped taking people there from the Australian shores, were people still being taken there having been intercepted in boats in Australian waters?
So the way the policy has played out in Australia is that people who were either intercepted or rescued at sea were all brought to Australia first and detained in Australia, at which point they went through health, identity, security screening for a certain period of time. So at that point, once they've all been brought onto Australian soil and detained, that is when our obligations towards them were engaged. Then at some point after screening, they would then be put on planes and flown from Australia to either Nauru or Papua New Guinea. And the last time that happened was in 2014.
Thank you. We want to ask some further questions about what happened and the way in which the offshore processing centres have worked and the implications. But we're going to go next to some of the issues around the turnback policy and the approach to that. Diana Johnson.
Thank you very much, Yvette. Professor Klein, I was very interested in what you were saying in terms of the turnback policy, and we know the Australian Maritime Powers Act 2013, which was amended in 2017, states that as a maritime officer may detain a person on a vessel and take the person to a place outside Australia. And this, we understand, has been taken through your court system. And I think in your highest court, there was a majority decision to uphold that law. I just wondered, you mentioned a whole array of international obligations and conventions. Could you just say something more about where that leaves Australia in terms of its obligations internationally? And could you also say something more about your comment around the Council of Europe and the UK's being a signature to the European Convention on Human Rights, and how that might be different from what's happening in Australia? Thank you.
Mm-hmm. All right, thank you for the question. Yes, Australia has the Maritime Powers Act, and Section 72 of that Act does provide the authority that you mentioned, and it does go partway to providing Australia's implementation of the Search and Rescue Convention in terms of setting out a requirement that when Australian officials are to take somebody to another location, that they are to ensure that that is essentially a place of safety. And that's a fundamental component of the search and rescue obligations, that you rescue someone who is in distress and take them to a place of safety. So what counts as a place of safety has been a question of discussion within Australia. The Australian government has had a more limited approach on that. A number of commentators believe that the place of safety has to incorporate protection of human rights. The particular case that you referred to that went to the High Court, in the end, that case turned more so on particular executive powers. It did not address, the judgment did not address the question of whether the legislation was consistent with Australia's international obligations. So that aspect was not fully ventilated and really resolved before the Australian High Court. So in relation to the conformity with the different international obligations, Australian officials do follow the Search and Rescue Convention in terms of going to the assistance of a vessel that is in distress and trying to assist the people who are there. And they've been doing that in different ways, we hear, through the turn back policy, and at one point that extended to actually providing people with their own life rafts in that situation. But the key difficulty that emerges for the Australian practice is that when the Australian officials exercise control over the individuals concerned, then under human rights law, that's the point that your obligations in terms of, the human rights law related to prohibition on collective expulsion, ensuring that there's not arbitrary detention, making sure that that you're not denying these people an effective remedy, and particularly giving people the access to a procedure to determine their refugee status. All of those obligations begin at the point that a state official is exercising control over that other vessel. Now, that obligation is true for Australia under the International Covenant on Civil and Political Rights, under the Refugee Convention, under the Convention Against Torture. The thing is that there's not many ways to hold Australia accountable under those particular treaties. And I think it's fair to say Australia's had a spotted record when it comes to responding to recommendations that have emerged from the committees under those treaties. I say the situation is different for the United Kingdom because it can be held accountable before the European Convention on Human Rights. And as you probably know, there was a case against Italy about the fact that it had been involved in rescuing people on a particular vessel. They held those people on that vessel for about 10 hours. They returned them to Libya, and Italy was found to be in violation of various provisions under the European Convention on Human Rights as a result of those particular actions. So the difference that I was trying to make between Australia and the UK is that Australia is not part of a regional human rights mechanism for which it is held to account. Potentially complaints could be made through to the human rights committees, but that would entail exhausting domestic remedies, and so far that whole process has not gone through the Australian system so far for those complaints to have emerged at the international level.
Okay. Can I just ask, obviously on a boat, with an official making a decision, that there's no obviously an opportunity for individuals to have any access to advice or legal counsel about what their rights are. So I also noticed in our briefing that the Australian government seemed to be very reluctant to provide data and information about numbers, and I just wondered, is that that's very surprising, because obviously we hold Australia in high regard. Could you say something about that, about how data is available to you to see what is actually going on?
Yes, shortly after Operation Sovereign Borders began, we went from daily briefings to monthly briefings where the amount of information being released about Australia's operations on water were significantly restricted on the basis of security, and that has been the ongoing view of the government, that it does not want to discuss on-water operations for security reasons. So we have got some information about what has happened at sea based on accounts of people who were returned to Indonesia. This is how we learned more about the fact that migrants and asylum seekers were placed on lifeboats provided by Australian authorities and sent back to Indonesia. And also we have some statistics that have been gathered through different parliamentary committees on the numbers that have been drawn from different sources. So we do have some information available about that. I've dug that out today and found that there's been almost 900 people have been returned from 38 ventures since 2013, based on the information that has been made available so far.
Okay, thank you. Thank you.
Tim Lawton.
Thank you, Chair. Can I just turn to the subject of international maritime law? And I absolutely recognise the difference between Australia and the ECHR provisions, which we're subject to in the UK. But there's been dispute between the UK and France as to whether they can use international maritime law to intercept the boats coming across the channel, which is the big issue of contention. I gather that under Article 17 of the UN Convention on the Law of the Sea, states that subject to this convention, whether coastal or landlocked, enjoy the right of innocent passage through the territorial sea, is the quote. So under what conditions is a vessel deemed to be not innocent for the Australian naval patrol vessels to intercept them?
Right, well, you'll see also under Article 19 of the UN Convention on the Law of the Sea, it goes on to list a range of different acts that are considered to be prejudicial to the peace, good order and security of the coastal state. And included in that list of acts is the unloading of persons in violation of immigration laws. So if a vessel comes through and it is unloading people in violation of immigration laws, then that vessel is no longer exercising a right of innocent passage. Under Article 25 of the UN Convention on the Law of the Sea, the coastal state can then take what's set in the convention as necessary steps to prevent the passage of a vessel that is not innocent. In addition, depending on the laws that are in place within a particular country, they can exercise criminal jurisdiction over particular acts that occur within the territorial sea as well. The main thing that you need to bear in mind in terms of the right of innocent passage, that if a vessel is in distress, then that is an acceptable basis for a vessel to enter the territorial sea and indeed to enter into the port of a state, even if that state is attempting to close its port to certain vessels or to particular countries. An exception applies in that situation if the vessel is in distress, and it is for those on the vessel to determine whether it's in distress or not, and to make that case as the justification for entering into port when it might not have otherwise been allowed to do so.
Understand. Okay. The problem we have in the channel is that only when dinghies genuinely are in distress and at risk of sinking will they then allow, say, the French authorities to take them aboard and then return them to France. You presumably, therefore, would regard those dinghies which are coming across the Channel from France to England as a not innocent vessel, and then therefore subject to prosecution of whoever is facilitating what potentially could be a crime to land people in the UK as opposed to Australia who have no right to be there automatically. Is that your definition?
Yes, that is correct in terms of the exercise of authority, because a state has sovereignty over its territorial sea, so it can take those steps to police what's happening in its water. But also what you have to remember, the layer over all of this is because a state has sovereignty over its territorial sea, its human rights obligations also apply. So while it can take the steps necessary for policing against people smuggling, at the same time, it also has to respect the human rights of the people who are on board those vessels and who are not the smugglers.
So under what circumstances do the human rights of those people being trafficked trump the vessel's innocence being compromised by criminal activity?
I'm not sure that I would talk about it in terms of one trumping the other, but rather the vessel itself loses its right of innocent passage because it's in the process of trying to unload people unlawfully for migration purposes. But at the point that you would then potentially arrest a vessel or take other steps against it, at the point that you're moving to do that, the people on those particular vessels, if they're claiming asylum, then they have that right to have their particular claim to asylum assessed at that point.
But where does their right to have it assessed occur? At the point of of departure, or at the point of intended destination?
Well, if they're coming from France, they still have that right at the point that they were in France, as I understand your question. I hope I'm following it correctly. There has been an ongoing debate about whether the Refugee Convention applies in maritime areas. This is a position that the United States has argued against, but the weight of authority has actually gone against the United States position now in terms of the Refugee Convention having application at sea at the point that a government is exercising authority over a particular vessel and those on board.
But my understanding of the 1951 Refugee Convention is that migrants seeking asylum are only deemed to be lawfully doing that if they're coming directly from a dangerous country. Clearly that is not the case with those coming from France across to the UK. You see, the problem we have is the French authorities seem to be challenging whether they have the power to intercept or detain those migrant boats who are in French territorial waters setting out for the UK. So they claim that they haven't got the power to do that. What you've said suggests that they have. And then secondly, they'll also claim the fallback of the Convention on Human Rights as well. But then there's a grey area as to where that actually applies if you're in mid-channel effectively. So just to get it clear, my understanding is that if you were the French, you would say that they do have the power under the conventions that we've just discussed to intercept and detain those migrants. It's then less clear as to what the rights of those migrants are being allowed to carry on with their journey or resist being taken back to where they started under Convention of Human Rights, and that they wouldn't have an automatic right under the Refugee Convention of 1951 to enter the UK legally because they're not coming from a dangerous country. Is that a fair surmise of what you said?
Yes, I think on the whole, because in that situation, I think you're correct that France does have that authority to exercise, and indeed it also has an obligation to respect the human rights of the people on board. So in that particular context, France also has its responsibilities and should be undertaking the assessments and providing protection in that context.
Thank you.
I don't know whether Madeline wants to
Yes.
say more about it, the point that the Refugee Convention applies an arrival to a particular state.
Yes, sorry, Ms. Gleeson, I didn't mean to monopolise with the Professor, but do you concur with those thoughts as well?
Would you mind rephrasing for me what the question is exactly that you would like the advice on?
There's 3 points. My understanding is if we apply to Professor's interpretation of the UN Convention on the Law of the Sea, that France does have the right to intercept and detain people caught in French territorial waters heading for the UK. That is effectively what Australia has done. Secondly, there is this rather more grey area of what rights those migrants have under the European Convention on Human Rights. But then thirdly, there seems to be a grey area of whether they can have those rights applied back on French territory, having set out in a boat, if they're intercepted in mid-channel in French territorial waters. So would you agree with those 3 scenarios?
Understood. I think for the most part, I will defer to the experts in the law of the sea and the experts in European law on most of those points. Only 2 comments to add. The first was, I may have misunderstood, but I think when you were describing the proposed French conduct, you compared that to what Australia is doing, and in fact it's the opposite. So Australia is not preventing people from leaving our waters. We're preventing them from entering or having entered, we're then returning them. So it's not directly comparable in that sense. And then in terms of referencing the Refugee Convention, I'm not sure if it was Article 31 that you were referring to, which was about that contracting states will not impose penalties because of having entered illegally on refugees who came directly from a territory where their life is threatened. So I'm not sure if I heard that language about coming directly from the place where your life is threatened, but if so, Article 31, that is about that the UK, say in that instance, being the country that would be receiving them, cannot penalise them simply on account of them having entered unlawfully as per UK migration law. So I'm not sure if that is really on point with what you're really asking, which is about the conduct of the French in terms of the vessels. That is possibly a different point, on which I will defer to the experts.
Okay, I may be wrong here, but my understanding of what is a lawful migrant crossing, so it is illegal. You are committing an offence if you try and enter the UK unlawfully, if you have no right to enter the UK and you're doing it covertly, unless you are an asylum seeker, a genuine refugee, coming directly from a dangerous country. Now, clearly we don't have that issue because we don't have people coming by boat, for example, directly from Syria or from other dangerous countries. They come from safe other EU countries. So therefore, anybody coming across in a boat is potentially committing an unlawful act, as well as the people who are facilitating that, because they're not coming directly from a dangerous country.
I think I think that is mostly correct, though it would also be worth bearing in mind that under the Migrant Smuggling Protocol, to which the United Kingdom is also a party, there is strong provisions in that around the fact that the people who are being smuggled are to be treated differently to those who are undertaking the smuggling operations, so that even if they've committed a migration offence, that does not in and of itself deprive them of rights that they would otherwise have under international human rights law.
Thank you. Adam Holloway. Adam is on audio, but I hope we can hear him. Pause while Adam tries to unmute himself.
Not.
Okay, we'll investigate our technology again and hopefully come back to Adam. So I want to go on to Diane Abbott.
Am I muted?
Oh,
sorry,
actually,
am I muted?
We've got Adam, so we'll get to Adam now.
Thank you very much. Yeah, there seems to be something happening centrally with that. You may not be the correct people to ask, but my understanding is that under French law, you're generally required to assist a person in danger and to operate a boat above 5 horsepower in France, you require something called a carte mère. So is it not the case that not only, the French authorities should indeed pick these people up because they're operating boats illegally?
I definitely can't speak to French law on that, so I would have to defer to other witnesses who are more familiar with the French law.
We are going to be pursuing that at a future evidence session. Adam, did you have any further questions?
No, that's great. That's great. Thank you.
Diane Abbott.
Thank you very much, Chair. I wanted to return to the subject of offshore processing of asylum seekers. And first of all, I wanted to establish with Gleeson, you said that most of the people not offshore, they're actually in Australia. But how many are still in Papua New Guinea and Nauru?
Less than 150 in each place.
And can I ask, is Papua New Guinea being paid to facilitate this, or has it just agreed to do it of its own free will?
It is incredibly difficult to get clear, accurate, specific answers as to the money and the funding of this entire scheme. It has been from the beginning. We are able to get certain figures about what offshore processing has cost Australia in terms of the direct management of the centres, etc. In terms of what parallel aid agreements are in place with Nauru and Papua New Guinea, it is a lot harder to speak to the specifics of that, but suffice to say that Australia has to offer something to these countries for them to agree to what has also been a very difficult policy for them to implement and for them to host these centres in their countries. But the specifics of exactly what that aid is and whether there are conditions tied to it or if it's more of an agreement, it's harder to pin down. And that is partly about the fact that in the Pacific, Australia supports many of our Pacific neighbours. And so it can be a little bit hard to fully disentangle the offshore processing aspect from the broader relationship that Australia has with Papua New Guinea, Nauru, but also other Pacific Island nations.
Thank you very much. It's interesting to know there's only 150 in Nauru and another 150 in Papua New Guinea. As you will know, back in 2014, the United Nations Committee on Torture expressed its concern about the policy of offshore processing, and in particular expressed its concern about what it described as the harsh conditions prevailing in those centres, such as mandatory detention, including for children, overcrowding, inadequate healthcare, and even allegations of sexual abuse and ill treatment. Is that still the case? Have there been any improvements in conditions?
There's certainly been no improvement. I believe what you cited then was about 2014 from that quote at that time. So to give a bit of an indication, in 2016, UNHCR medical experts found that the cumulative rates of depression, anxiety, and PTSD amongst the refugees in both places were the highest recorded in the medical literature to date, with over 80% in both locations. That was in 2016. Still, the policy continued. And then in 2018, Médecins Sans Frontières said that the mental health suffering on Nauru was amongst the worst they had seen, including in its projects that provide care for victims of torture. Obviously, MSF works around the world in some very difficult settings. So the fact that these centres were up there as the highest rates of mental suffering they'd seen, I think indicates the level of harm that continued to exist for those people. And as I said, the vast majority of the people are now back in Australia. That's about 1,200 people have been transferred back to Australia. For the vast majority of them, the cause for the transfer back to Australia was physical and mental health suffering offshore. So it finally reached the stage where there was no choice but to bring them back to Australia after all. Although for many, if we think that those conditions were already identified in 2014 and in fact earlier in 2012, by the time they were brought back to Australia, much additional harm was done that could have been avoided, and for some that harm may be irreparable.
Thank you very much for that information about the level of harm. If there's anything that you could write to the committee about in relation to the two reports that you referenced, that would be helpful. As you're probably aware, here in the UK, our Home Secretary, Peter Patel, the media was reporting that she was considering looking at the Australian system of offshore processing. We wrote to her about this and she wrote back and gave quite a bland reply. Of course, government officials have been looking at a whole host of measures other countries deploy to inform a plan for the UK and bring innovations into our system. As she's looking at a whole host of measures, what would you say to our Home Secretary about the Australian experience of offshore processing of asylum seekers?
I think it's deeply concerning that any country would consider trying to replicate what Australia has done. I think I made the point earlier that it wasn't effective in the policy goal that it was seeking to achieve. And on top of that, the legal and humanitarian concerns should be cause for great pause, certainly for any state which is a signatory to international conventions, but more than that, any state which considers itself to be a democratic society based on respect for common decency, really. And in reflecting on those statements, which I also read, I thought about a few of the structural aspects of offshore processing that the UK would need to be willing to commit to if they wish to pursue this model. And the first is an unwavering commitment to deterrence as your core objective. And for Australia at least, which is admittedly in a different position from the UK geographically, but that means that Australia had to be willing to subject people to worse conditions than that which they were fleeing. If Australia wanted to deter people from coming by boat to seek asylum, we had to be promising them in Australia that they would meet something worse than what they were currently in. You have to be willing to deport and detain children, pregnant women, the elderly, disabled, victims of trafficking. There can be no exceptions, because if vulnerable people are exempt from this policy, then its core objective of deterrence will fall down. You will need to have no national or regional human rights framework whatsoever, no national or regional court that could adjudicate claims based on violations of human rights, as we don't have in Australia. You would need to introduce laws and policies that impose strict secrecy requirements. So, for example, in Australia, if somebody working in one of these offshore centres were to talk publicly about what was going on in that centre, they would be subject to 2 years imprisonment for having spoken about that. And that's not speaking about classified national security information. That is talking about the common comings and goings of the day. They could be subject to 2 years in prison. It also originally covered doctors who might be raising concerns that they were seeing with patients there. You would need a place that could accommodate an unlimited number of arrivals. Otherwise, you're going to hit the problem that we did 12 weeks in, that if people come in too large a number, they're going to outstrip your capacity there. And then finally, you have to have a lot of money. A conservative estimate is that this costs Australia roughly $1 billion per year. And so to bring us back to those numbers at the beginning, the financial year 2020 to 21, it's estimated to be above $1 billion. That is for 300 people. So I guess the UK would need to calculate how many people is this going to be for, and what is that going to end up in terms of a taxpayer cost for a policy that still might not work.
Sorry to interrupt you. Why is it such an expensive policy?
It is incredibly difficult and expensive to, at the front end, establish these centres in remote places. We have then contracted private companies to manage the centres and provide all of the services. Holding people in detention is always far more expensive than providing them a residential alternative. Then there are other costs. So the big issue for Australia is we've never had an exit strategy. There has never been an answer of what will happen to people once they're found to be a refugee. There was an aborted attempt to enter into a resettlement arrangement with Cambodia, whereby Cambodia was going to be paid by Australia to accept people who had been found to be refugees on Nauru. That was earmarked in the budget at $55 million, and only 7 people went, of whom at least 5 then left. So that's up to $55 million for 2 people to go to Cambodia. The costs blow out in a policy like this.
Thank you very much. That's very useful. No doubt the Home Secretary will be reading our report and your remarks. Thank you very much, Chair.
Thank you. Stuart MacDonald.
Thank you very much, Chair, and thanks to our witnesses. Just to follow up on Diane Abbott's questions there about the offshoring policy, could I just sort of seek some clarity about what happened to people who were on these islands but refused asylum, but at the same time couldn't be returned to their countries of origin, perhaps because the governments weren't taking them back? And secondly, given the conditions on these islands, to what extent would folk voluntarily, in a very loose sense of the word, then choose to be returned home, and what steps were taken, for example, to make sure that they were safe if being returned to Afghanistan or other countries like that?
Thank you. That's a really important question. It's been a problem from the beginning that when people, if I can go back to 2012, when people were first sent offshore at that time, the understanding was that they would be processed under the laws of Nauru and Papua New Guinea, but neither country had laws in place for refugee status determination, nor did they have any capacity to do RSD. So people were sent to these camps with no answer of what the process would be or when it would start, how long it would take. As I said, there was no answer of what would happen if found to be a refugee. For many people, there was no end in sight. And for those who had come without their families, they were facing the prospect of indefinite detention in incredibly difficult situations physically, separated from their family. And so many people chose to return back to the places they had fled, despite, I would argue, having a high likelihood of success in a refugee claim, simply because the entire environment was set up to deprive people of hope that there would ever be a solution. And that has been a fundamental feature of offshore processing from the beginning. Quite often when there were sort of flashpoints, tension points in the policy, people in detention would come and seek clarity of what was happening to their case or what was the future going to hold. And most commonly the answer would be, we have no answer for you on that, but if you would like to return home, please go and speak to these people over here and they will facilitate it for you. And that includes return to Syria in the peak time when nobody was returning anyone to Syria. Syrians were being encouraged to return home, and some Syrians did.
And do we know very much about what happened to people who voluntarily returned? I take it was just see them off and then that's it, no more interest?
Very little is known, and it's a similar situation for the people. We focus on boat turnbacks, and that's obviously the people who are at sea, either pushed back to Indonesia or potentially handed over at sea to the authorities of another country, such as Sri Lanka. But there are also people who are intercepted at sea, brought to Australia, and then flown back to, say, Vietnam, perhaps, or China. Similarly, we find it very difficult to follow what's happened to any of those people once they've been returned. So policies that involve forcibly returning people to places they've fled, places they face harm, and then no adequate follow-up of what's actually happened to them, that's not unique to the offshore processing component of Australian policy.
Sure. Can I ask, if people arrive now in Australia by boat, as I understand it, there are very different procedures and policies that apply to them as compared to, say, an asylum seeker who has flown in on a different type of visa and then subsequently makes an asylum claim. Am I right in understanding that?
Absolutely right.
Okay, and could you just describe some of the differences? I think there's some sort of delay before you can apply. There are different rights in terms of length of residence that you'll get, access to illegal assistance and family reunion rights, for example.
Certainly, there are many differences which are essentially based on trying to penalise those who arrive by boat based on their mode of arrival. Family reunion is the big one. Now here it's difficult to say with exact precision because there are so many cohorts of people who have arrived, and our Migration Act has been amended so many times that to work out exactly what policy applies to which person can be a very complicated task. But in general, if you arrive by boat, you are unlikely ever to be reunited with your family. That is either because you are outright prohibited from having family reunion, or it's because your application for family reunion will go to the bottom of the priority list. And with cases always coming to the top, that means they're never going to get to your family. So for one reason or another, the practical effect is no family reunion. The other very critical issue we have at the moment is that if you arrive by boat under the current policy, if you arrive by boat under the current policy, you won't stay in Australia, you will be returned. But if you arrived by boat previously, then you are subject only to temporary protection visas, potentially forever, and have no pathway at any point to permanent residency or citizenship. This is a policy that Australia had previously under John Howard as part of the Howard era package of policies, which also was the first time we had offshore processing. And there have been extensive reports on the damage it does to people and to communities to have large groups of people on rolling temporary visas rather than ever having a pathway to permanency. So that's just another example. The temporary visas and the lack of family reunion are probably the two biggest differences which cause the greatest impact for people.
Are there not legal questions over whether or not that is really consistent with the Refugee Convention, or I don't know what other international laws might apply? Has that been challenged?
There are absolutely questions. The answer always comes back to the fact that in Australia we have absolutely no Bill of Rights or Charter of Rights. We have no court. So our courts cannot hear these claims to the extent that they go to a violation of our international obligations. Any attempt to get cases up through the courts need to try through other routes, but aren't successful because they can't bring the direct claim. So that's a very real issue that we face.
And is there evidence, and does the government try to say that this has had a deterrent effect and that justifies it?
They do. I guess the second part of my answer to your previous question, which I should mention, is that our laws have been amended to explicitly state in various parts that the powers they grant are validly executed, validly acted upon, even if they violate Australia's international obligations. So besides the fact that we don't have the legal framework or the courts to challenge violations of human rights, we have legislation which explicitly states that conduct by Australian officers is valid even if it is contrary to our international obligations. So that's another concerning aspect to it. In terms of the deterrent effect, yes, that is the argument. The argument is in 2012, 2013, we had 25,000 people coming on boats, and now we have zero. As I've mentioned, and Professor Klein, the number is not zero, but it is still less than 25,000. And so long as they report it as zero, the justification is the Australian model worked.
And do you attribute the fallen numbers to that, or I think I picked up, is it earlier to say it was really the policy around pushbacks that had made the biggest difference?
I'm just going to interrupt you before you answer that question. We're coming up to the 2-minute silence and the parliamentary bell will go in a minute just for us to mark the minute's silence. So if I could just hold that thought there and ask you, Ms Gleeson, to come in and to respond to Stuart's question after we have done the 2-minute silence. I'm going to suspend the session temporarily. Order, order.
The proceeding is currently suspended. 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 The proceeding is currently suspended.
Order, order, return to our evidence session. Thank you to everyone for observing the remembrance and for the time we spend to think of those who gave their lives to keep us safe. Return to the questions that we were asking. We had Stuart MacDonald's question. Madeline Gleeson, do you need the question again or are you ready to answer?
That's fine, I can answer.
Thank you.
So the question was, as I understand it, whether the deterrence effect can be put down to the boat turnbacks alone or whether it's all of these policies as well.
I just wanted to know, is there anything to back that up? I mean, on one level, you can have this discussions on a point of principle on whether the right to do legally justifiably, justifiable, morally justifiable. But I just wanted to know, is what the Australian government says about it having a deterrent effect backed up by evidence? Is it, can it be attacked in a different way?
Certainly. I understand that the Australian government was originally going to appear on this panel, and it's unfortunate they haven't, but perhaps I can start by giving their response to that question and then perhaps critique it afterwards. So the Australian government's position on this point is that you need every one of these policies working together in order to create the deterrent effect. You cannot be seen to show any humanity or any chink in the armour, as they might put it, on any of these policies. Family reunion, detention offshore, boat turnbacks, all of it is required to deter people from coming by boat. I don't think there is evidence to support that claim, to put it back the other way. I don't think there is any evidence to support the fact that putting someone in detention for a few years is going to be a deterrent effect, because we saw when we had that policy alone that it didn't work. In terms of temporary protection visas, etc., when we look at the reality of the people who are coming to Australia, and the vast majority of people who come to Australia by boat are found to be refugees, and they are coming either directly from a place where they fear harm, or from a place like Indonesia, where they don't necessarily fear harm in Indonesia, but they have no prospects of protection there, so they're going to have to move on to somewhere else. So people have no option where they are. And I don't think there is any evidence to support the claim that if you come to Australia and you're subjected to difficult policies for 5 years or 10 years even, that people wouldn't still perhaps take that chance, thinking that in time there might be a policy change, or that an opportunity might present itself. At least you're in Australia, at least you're here. I think that the only thing that's actually serving as a deterrent is the fact that there's no point getting on a boat because you will be turned back around or you'll be flown back. And so there's no evidence to prove one bit or another because they've never been properly tested one by one. All we can say is that offshore processing didn't do it.
Thank you. I've got just two final questions then. So on the one hand, that's a sort of critique of the justification about deterrence, but stripping asylum seekers of those rights must have a pretty horrible impact on their lives meantime. Has that been looked into and documented?
It has. Certainly the first time around that we had temporary protection visas, there was comprehensive studies of, as I said, the damage that it does, not just to the people who are on those visas, I should say, but also to the communities they are in. If you come at this issue from a community cohesion perspective, if you're looking at having Australian societies which are working well together and where all members of those societies are, equally participating and buying into, I guess, the social contract of that community, there are strong advantages to having people who are, permanently here with rights and engaging in Australian society and becoming Australian citizens. There is far more advantage to that than having people in indefinite, temporary, precarious situations.
Thank you very much. And then finally, if I could just take you back to the discussion you had earlier about Article 31 of the Refugee Convention and the issue about how that would apply to people on the Channel. My understanding is that it would only really apply if the people crossing the Channel had been granted refugee status and settled in a country in between time, so that they would be, the use of the term illegal would apply to them. But if somebody hasn't had asylum or been granted and recognised as a refugee in between the country that they've escaped from and the United Kingdom, then the use of the term illegal for that crossing wouldn't apply at all. Is that right?
That would be my understanding, yes.
Okay, thank you very much indeed.
Thank you very much. Diana Davison.
Thank you very much, Chair, and thank you to both of our witnesses. One of my key questions really is kind of about public opinion of both of kind of migration as an issue in itself, but also of the Australian government's handling of migration, particularly since sort of 2012, 2013. So if you could give a kind of steer on how public opinion's been reflected, that'd be really appreciated. First to Ms. Gleeson.
Thank you. Public opinion generally, I will say, is either neutral or was either neutral or supportive of these policies. There is a strong preoccupation in Australia with people arriving by boat and perhaps a sense of the uncontrolled border and what might happen if we don't regulate the number of people that are coming by boat and the way in which people come to this country. That is a preoccupation that predates any of these policies. It's something that has been long in the Australian consciousness. So when a government comes in and plays up those fears and then offers what seems to be a solution, that is certainly something which is generally politically quite popular in public opinion. That said, I mentioned earlier the secrecy that's been required around this policy, and I do think that playing to those fears only gets you so far. Part of the reason it's been able to get so far in Australia is because the detention centres that we have had in Australian territory traditionally are in quite remote areas, so people don't really see what's going on. Christmas Island, which is Australian territory in the middle of the ocean, is one of the main areas where we have traditionally kept asylum seekers. That is completely inaccessible to the average Australian person. And then obviously Nauru and PNG are remote. There was a long time when, with our offshore processing policy, there was no access to those centres. Media could not get in, even independent observers that internationally you would expect to be able to access those camps. They faced difficulty getting in. There was intimidation, there was threats. We then had the introduction of that law, which imposed 2 years penalty on anyone who spoke up. So there was a lot of pressure not to disclose what was really going on in those camps. Since they started to open up and information started to get out, there have been small shifts in public opinion. I won't say it's widespread, but they are particularly around certain issues, and children was the big one, because the impact of these policies on children has been devastating, and I think that's an understatement, devastating. And certainly I would say if the UK is seriously considering this policy, that they should seek evidence from the child psychiatrists who have worked with the children on Nauru who have resignation syndrome, and get a sense of what the impact of this policy is. So once the impact on children started to come to light, there were particularly shift around that, and that translated ultimately in the government being forced to remove all children from Nauru. Similarly, there were cases of abuse, sexual abuse and rape of women in Nauru. A certain number of them fell pregnant as a result of those rapes. There was then some highly publicised cases where they had to be flown to Australia to terminate those pregnancies. These types of issues really captured sentiment and attention, and we got small bits of change around that. So there is some scope for change once the information started to come out, but as a general rule, Australians remain very preoccupied with people coming by boat.
Thank you. And Professor Klein, would you agree with that analysis?
Yes, I would. I wouldn't have anything to add to what Ms. Gleeson has said.
Thank you. And then sort of final question from me. If you could sort of speak to the UK government, who are, certainly looking into policies like Turn Back the Boat and seeing if the UK could introduce its own sort of version, what advice would you offer? Professor Klein?
My advice would be twofold. I think there is actually some progress that could be made around improving policing operations, and there's quite scope for change in that regard. And obviously a key aspect would be enhancing cooperation with France, particularly in the point of the channel where the territorial seas overlap in that regard. There should be a way to coordinate perhaps policing efforts in a way that could still respect the rights of those who are on those particular ships. And that there's certainly improved technologies. I'm aware some of those are being deployed in the channel as well to try and detect boats that are coming in, to be able to determine from the movement of the vessel whether they're in distress or not, and to be able to render assistance more promptly than has perhaps been the case in the past. But I think the other key point is always bearing in mind that there is a very strong humanitarian dimension, and that there are, we say in Law of the Sea, elementary considerations of humanity that apply to people who are at sea, and particularly those who are in need of assistance, and that assistance needs to be afforded. And when you're rescuing people who are in distress, they need to be taken to that place of safety, and they need to have their rights respected in that. So it's a matter of trying to find the balance. I think a lot of the approaches around dealing with migration by sea is very much focused only on the policing aspects and on concerns about security, rather than also taking into account the very real humanitarian aspects that are also inevitably involved here too.
Thank you. And Ms. Gleeson, what about yourself? What advice would you offer to government?
Thank you. It's an excellent question. Obviously, the challenges of forced migration are very real, and many countries around the world are grappling with them. And I don't think, I think it's a good thing to look at what other countries are doing and see what lessons there might be there that could apply in your own country. But two lessons I think to take from the Australian context. The first is we unfortunately fell into a trap where there was this dichotomy or divide between so-called principle and pragmatism, that you had the people advocating for human rights and humanitarian issues and the law on one side, and then you had the pragmatic people who realized this as a genuine problem and were just getting on with fixing it, and that you had to fall in one or the other. And that's a very dangerous division to allow to take root, because what it gets to is, well, we're going to do this deterrent policy which has terrible consequences, or
we're going in that direction, and it gives up from the outset any hope of finding an option which is both practical, which addresses the very real challenges that your country is facing, but also does so in a way which respects international law and UK law and human rights. So I think don't fall into the trap of feeling like it has to be one or the other, because there are routes forward. It just takes a bit of time to find them. And the second lesson is something which we strove for in 2012, but we lost it. We went off course, was the idea of incentive and disincentive. Australia went too far on the track of deterring irregular migration and not enough looking at the other side of that coin, which is creating safe, lawful, accessible pathways to protection for those who are in need of it, or for children who are joining family members, etc. And often I think where the balance gets thrown out is a similar point to Natalie's. There's too much emphasis on how to stop the irregular migration and not enough looking at what the issue is, looking realistically at what the UK could do to address it, and then creating pathways so that people don't need to get on boats because there is another option open to them.
Thank you.
Thank you very much. Laura Farris.
Thank you very much. Can I kind of pick up with your last answer about the tension that you saw between human rights and pragmatism? And can I just firstly clarify one of your earlier answers? I think I misunderstood or misheard you. When you were talking about the refugees who would be relocated to one of the various designated locations, and I think you said that they would then be processed by the asylum laws that were applicable to that jurisdiction. Is that correct?
That's correct. That's a difference. In 2001, it was Australian officers and a few UNHCR officers doing it under effectively Australian procedures. But the second time around from 2012, the idea was that Nauru and Papua New Guinea should each create their own laws and their own officers that would do it themselves.
Can I just then, picking up on that, because we have a web of human rights laws that are applicable in this country, could you see a scenario where the United Kingdom, in principle, found an offshore location, obviously created some sort of detention facility that was compliant with the Article 3 obligations under the European Convention? And I mean, you could even, for example, in our case, have something like the UN Special Rapporteur who would observe that and would, verify that conditions were adequate. And then a right to make an asylum claim in the United Kingdom in accordance with domestic laws, a time frame in principle in which everybody would have their first application heard. With a sort of framework like that, would that sort of alleviate some of the very serious problems that you've identified with this process? So really, what I'm suggesting is a detention centre that is in effect of the same quality, so a domestic detention centre would be anyway, then clear and well-published sort of asylum laws, and you would make your application in accordance with those laws, and obviously in accordance with the with the Human Rights Act, actually, which would be applicable. And then also a time frame in which you would be guaranteed to have a decision, and I guess a right of appeal as well. But again, you could in principle have the same time frame for that to be determined. And at that point, the asylum seeker would know whether or not they had had their claim accepted, and at that point they would either be admitted to the United Kingdom and then on the pathway to citizenship, or they wouldn't be. Do you think in principle that could work?
That's an excellent question. It's certainly something that I've spent many nights thinking about since 2012. If we could go back to 2012, August of that year, and do things differently, could we have done it better? Could this policy have been done in a way that wasn't so detrimental? Now, the issue in Australia, which might not be the same issue in the UK, so this is where there could be a difference. But the issue in Australia, as I've said, was the main purpose of doing this offshore was to punish the people who had come that way and to instill fear in those who might come that way in the future. Deterrence was our main policy. We at all times had physical capacity. I mean, the most we're talking about at any one time was say 2,000 people, perhaps 3,000 people. At all times, we had physical capacity to host those people in Australia and process them here. So it was never a matter of physical capacity, it was deterrence. What you're proposing there, I can't see how it would serve the deterrent effect, because they would come, they would have a fair and efficient process. If found to be refugees, they would have access to protection. It sounds like there are guarantees of law, that the conditions of detention, I presume, would be time-bound, not punitive. In that case, I can't see how it would serve a deterrent effect. So unless there's some other reason for doing it offshore, then doing so just runs you into, as I said, all the expense and the complication and the difficulty of doing it in a remote location. The big question mark I would have is where that location is, because the remoteness of our offshore centres contributed to deaths. When people got sick and could not get to health in time, deaths resulted. So it would have to be somewhere that had sufficient healthcare and all of those things. If the conditions they were facing were identical to if they were in central London, then I guess it would be for the UK to decide whether it's worth all the expense of putting them elsewhere.
Well, I think, just to come back, I think and I don't know that this is the Home Office's thinking, but it could be the case that simply saying that just the basic fact that you don't land on UK soil, you're never part of the domestic arrangements. And I mean, this would require some kind of carve out, but if they were to say it is then you're either admitted because you cross the threshold of our asylum laws and are treated as an asylum seeker and then are properly lawfully admitted to the United Kingdom, or if you're not, then we have no responsibility for you. So then essentially a process of return. Could that in principle, do you think, have a deterrent effect? So I suppose the idea being that there is no guarantee, all you're guaranteed is the right to make an asylum claim, but let me put the question a different way, none of the rights that would come from having landed on UK soil. And there are rights. It
didn't have an effect in Australia for the people that were subject to that policy in 2012. When they compared to what their alternative was, then whether they were in Nauru or whether they were in Australia, if the end result was that they would be in Australia within a few years and that they would have been subject to a fair and efficient process, then it didn't deter them. It didn't even deter them when they didn't have a clear and efficient process, when they didn't have a timeline, and when they were in terrible conditions, it still didn't deter them because of the places they were fleeing from. So I guess that would require an evidence-based analysis of who it is that would be subject to this policy, what are their motivations for entering the UK in this manner, and looking at those people and their motivations, that's how you would get a sense of whether this would happen. But if that is a route that you would like to pursue, then the UNHCR has published quite extensive guidance on this. They've said that as a matter of basic principle, signatories to the Refugee Convention should process people within their own territories. However, if they are to enter into arrangements where they transfer them elsewhere, there are a series of requirements that they set out, which is basically how you could do it in a way that's compliant with international law. And some of those are what you've mentioned. They are access to fair and efficient procedures, treated in accordance with basic human rights standards. There'd have to be access to durable solutions, protection against refoulement. So at least according to UNHCR guidance, if your question is one of principle, there is in principle a way that you could process someone in territory that is not your own, that is in accordance with international law. It would just be a matter of whether that serves the deterrent effect, if that is your goal.
So that brings me on to my final question. With your sort of background and experience and having considered the Australian model, obviously in the depth that you have, if you were designing a system that you think would be consistent with both pragmatism and human rights and have a deterrent effect, what recommendations could you make to the United Kingdom government?
That is an extraordinarily difficult question to answer in a short amount of time because these things are so complex. But I would first be gathering data, as I said, about who are the people that are coming to your country, what their motivations are, where they're coming from, do they have family already in the UK? That will help inform.
Assuming that data had been gathered already, it'd be interesting to see if there were even one or two principles that you think have not been sufficiently explored in Australia, for example.
In Australia, I can say we have not sufficiently explored the safe and legal pathways to protection. That is the biggest one. And we are a resettlement country. We do resettle people, but one of the smallest areas that we resettle from is Asia. So while there is obviously need across the entire world, I think that there could be a more targeted use of our resettlement program. There can be a range of ways in which you identify people in need of protection before they need to go on long journeys and before they need to get on a boat. Identify those people, identify their protection needs, and then give them a pathway that's different. There is a body of work developing in Australia looking at visa pathways and other opportunities to use migration pathways, student visas, family reunion, community sponsorship, and Canada has had some success in that as well. There are many other ways that people can access protection, not just through traditional channels. And I think if half of the effort that Australia had spent into offshore processing was put into looking at those and working out whether they work and strategizing in that way, then that would relieve some of the pressure points where there are larger numbers of people in need of protection in our region. And then it would be building up capacity of other countries in our region to also increase their ability to support asylum seekers there. But again, Australia's in a very different position because most people, when they flee their country and travel to Australia, they don't hit a refugee convention country on the way. So what we're dealing with there in terms of geopolitically is that there is nowhere along the way that they could stop and get protection. It's very different to the UK.
Thank you.
Professor Klein?
Oh, I don't have anything to add to Madeline's answer there.
Can I then just ask just a quick few follow-up questions? Stuart McDonald asked earlier if there was any evidence of a deterrent impact from the overall policy, in particular the processing centres and so on. We heard Madeline Gleeson's response. Professor Klein, I just wondered if there was any evidence of the turn-back policy and the boat interventions policy having any kind of deterrent impact.
Well, we do know that the numbers have decreased over the years. So with the statistics that have been released from the Parliamentary Office that has assembled that, there has been a smaller number of people arriving by boat. So, and as Madeline has talked about, there have been stories that have come out that the fact that people knew that they would be turned back, that they couldn't stay, did have some deterrent effect in that regard. But we also know, it's not my particular area of expertise, but we know that the number of people who are now arriving by air has been increasing, COVID aside, has been increasing significantly in the last couple of years. So people are finding alternative ways given Operation Sovereign Borders and the consequences that's had for transport by boat.
That, I think, was then one of the questions I wanted to ask both of you more widely, is just in terms of the reasons behind the increase that you had initially up until 2013 in people arriving by boat and then the reduction after that. There's obviously a range of different factors involved. We've been hearing some evidence in the Channel about the reduction in the number of people trying to arrive by lorry, for example, had an impact on the approach that the different smuggler gangs were using. So I'm just interested in what the evidence or what you think the reasons are, both for the increase up until 2013 and the reduction after 2013 in terms of the number of people arriving by boat. Start with Professor Klein.
Well, I mean, Operation Sovereign Borders began in late 2013 in December. So it was the point that that operation began, as Madeline's talked about, the offshore processing had begun prior to that, but the numbers of boat arrivals increased. So it was when Operation Sovereign Borders began that we started seeing the decrease, and what we saw was a mix of operations being undertaken. We don't have all the full details. We know that in some instances it was just vessels being turned back. They were being prevented one way or another from continuing on their journeys to Australia. in some instances, they were what was known as assisted returns, and so the vessel, perhaps in the context of a rescue, was provided with some assistance and facilitated its return. And also we had situations where, as I think Madeline mentioned at one point, for example, with people arriving from Sri Lanka, where the Australian authorities would then also enter into communications with Sri Lanka or India in order to be able to return people there. In some instances, they were brought to Australia and flown back, or the vessels were taken back directly or on board Australian vessels at that time. So I do think we have to acknowledge that the physical activities of Operation Sovereign Borders absolutely decreased the number of boats coming, even though there, as I've indicated, there are a range of concerns about how those policies were implemented and the consequences for the people concerned. Certainly, I should also mention that Operation Sovereign Borders has had concerns for those who have been involved, the Australian officials who have been involved, for their safety in implementing this particular policy, because there were some reports that made into the media about the people who were on these particular vessels. They would sabotage their vessels at the point that they saw the Australian authorities. There were fires that were lit on these vessels to try and prevent them from being forcibly returned and then triggering a rescue situation. And there were concerns on some of these occasions for the safety and the security of the Australian personnel who were operating at the time. But we don't have full details about that because of the security justification that is given for the lack of information around that.
Thank you. Madeline Gleeson.
Thank you. I think Professor Klein has perfectly covered the second part of your question, which was explaining the decrease in numbers from 2013. I concur with her explanation. The first part of your question was going to the rise in numbers from about 2009 onwards. This is hotly contested, and because this is such a political issue in Australia, and at that time was such a hot political issue in Australia, there were all sorts of claims going back and forth of finger pointing and blame that this policy or that policy was leading to the increase in boat arrivals. The short answer is there is no evidence to support any of those claims. We do not yet have the full picture or understanding of why so many people were arriving by boat at that time. We do know that if you look at how the trafficking and smuggling networks were operating in Southeast Asia at that time, they were operating incredibly efficiently and effectively at getting people through the region and onto boats and down. If some explanation might come from what was going on in the world at that time and what might have been motivating people to leave their countries of origin at that time and why they might have been heading in this direction or why they might have been moving on from transit countries. But trying to reduce it to a simple set of push and pull factors is incredibly difficult, and no, that evidence does not exist. All we know is that from 2009 onwards, we did see a dramatic increase in the number of people arriving by boat.
And in terms of the reduction since, so did you say that one of you said something about there being some increase in people arriving by airplane or and so on? Is there any evidence of people arriving by different routes or any other factors that might be influencing it? Or any other policies that might have influenced the reduction as well that would be worth us being aware of?
I think there might be an argument that there was one other policy we haven't mentioned yet, which perhaps rounds out the picture, and that came in July of 2013. So it was a few months before Operation Sovereign Borders. And that policy dramatically changed what was happening with the offshore processing. So from August 2012 until July 2013, there was in place what was called the no advantage policy. This was not a policy that had any meaning that had been fleshed out yet, but in rough terms, it said that if you arrived by boat, you would not be processed any quicker or you would not be settled any quicker than if you had remained in, say, Malaysia. The idea was that you will not get any advantage by having come by boat as opposed to having stayed in the region and waited to have been resettled. That policy was highly criticised because there is no way to measure how long, if at all, it would take for resettlement from the region. But before the challenges of that were played out, in July 2013, a new policy was introduced, which was that if you arrive by boat, you will never be settled in Australia. And this was a fundamental break from what we'd had in 2001. So in 2001, the offshore processing at that time, the vast majority of those people who were found to be refugees were settled in Australia. Others were in New Zealand, and then there was a small number that went elsewhere. This policy meant that you would never be settled in Australia, but there was also no answer of where else you'd go either. So there might have been some claim from the government at that time that either instead of or in combination with the boat turnbacks, it was the statement that you would never be settled in Australia that was accounting for the drop in boat numbers. Personally, I don't find this reason convincing because people who come to Australia by boat are generally very well aware of these things once they get here. And this is a policy that could have been outweighted. This is not necessarily going to stop someone fleeing if they think, well, that will be their policy for a few years, but I'll wait it out and then see what happens. The other reason is that since then we've had the US resettlement deal, we've had 800 and something people be resettled to the United States. And that hasn't seen a massive increase in the number of people arriving by boat. So that policy has been chipped away at in the sense that people have been resettled elsewhere, and there still hasn't been any change in the boat numbers. So there is no hard evidence one way or another that this policy does more or less in terms of deterrence. All we know is the main indicator that has led to a change has been the introduction of Operation Sovereign Borders.
And then two final questions from me. How far has this also, is there evidence of this being driven by effectively criminal gangs who have got a business model and then changes to the business model? Because we've heard evidence around the operation of different gangs operating in terms of the channel, using different routes, and what ends up being effectively the most easy and the most profitable route for them. How far do you see that as being a factor in the Australian experience? Professor Klein.
I don't have specific information about the changes in the criminal operation, so I can't speak to that particular point.
Thank you. Madeline Gleeson.
I don't either. They exist as they do all over the world. They facilitate smuggling and trafficking in some way, but I don't have specifics about the ebbs and flows in the organisational structure.
Thank you. Then quick
that
final...
that I can speak to specifically.
Final questions then from me, which is... I think, Madeline Gleeson, you referred to there being a £1 billion cost for the 300 people for the ongoing, for the most recent financial year. Are there any costs for the maritime operations? Is there any evidence of how much that costs? Professor Klein?
I'll jump in quickly and clarify 1 billion Australian dollars, but
yes,
still a very large amount of money.
Yeah. Thank you. No, I don't have a dollar figure. I know that some costs related to Australia's turnback policies have come up before our Senate Estimates Committee, but I'm not aware of the amount to be able to tell you. I'm sorry.
Thank you. If you came across any figures
I can say,
and were able to let us know, that would be wonderful. And then just in terms of the overall cost, Ms Gleeson, that you referred to, that $1 billion was for the most recent financial year. What was the cost at its peak?
Look, that is taken as an average cost year on year of about that much, but I can provide further specifics to the committee if that would assist. In terms of the boat issue for the previous question, it's incredibly difficult to get answers on that because of the secrecy, the refusal to answer any real questions about what's going on at sea. It becomes, as a result, difficult to get information about the costs, but I can get information to the committee about the cost of offshore processing.
That would be fantastic. Thank you. It would just be very useful to have the sense of the cost over time and for different years, depending on the number of people involved. Thank you very much for your time, particularly so late, and thank you for your patience as well. We have kept you late into the night, so we very much appreciate both of your time and a very